4 hours of oral arguments on the free speech case. Your thoughts on what happened today?
Yeah, so I think, Ari, when you're listening to a Supreme Court argument, you're trying to evaluate where are the justices finding points of agreement. And I think, to me, the most significant interchanges were two. One was one that you just showed with Justice Kagan, in which Justice Kagan, who's just a masterful questioner, was basically saying to the states, who had, I think, a tough go of it today, she was basically saying, look, there are speech interests, First Amendment interests, on the side of the tech companies here as well. If YouTube or Facebook or whatever is forced to carry certain speech that they disagree with, that's itself an infringement on speech. So that's her point. And then Justice Kavanaugh followed it up later by saying, look, we decided in 1976, this very famous case, which, Ari, I know you know well, Buckley versus Valeo. And the principle of Buckley, Justice Kavanaugh said, is that you can't suppress some speech in order to enhance the views of others. And isn't that what this law is basically doing? You're suppressing the tech companies' rights in order to increase the speech of Donald Trump and other people who had been banned prior.
Let me play that.
So together, I think both of those.
Yeah, let me let you go on that. But first, just for viewers, we'll play. This is Kavanaugh citing that. And again, I've tried to translate some of this. The fact that you don't always love or agree with someone behind a certain policy doesn't tell you what the Supreme Court wants to do with it long term. There will be life after DeSantis, Trump, and the rest. In this case, I think it's relevant that what you're describing and what Kavanaugh is skeptical of is what sounds like the DeSantis position. Let's use state power to put a thumb on the scale because he wants to have a fight. And I think our viewers are familiar with his fights with Disney and other companies. Here was that moment with Kavanaugh.
It seems like in Buckley in 1976, in a really important sentence in our First Amendment jurisprudence, we said that the concept that the government may restrict the speech of some elements of our society in order to enhance the relative voice of others is wholly foreign to the First Amendment.
So if that view held the day, why would that be bad for DeSantis and these sort of government efforts?
Yeah, because this DeSantis law and the law in Texas is all about saying we're going to take some speech rights away from the tech companies and force them to carry speech with which they disagree in order to give those other voices, the Trumps or whomever, a platform. And that is what Justice Kavanaugh is saying is antithetical to the whole idea of the First Amendment. And I think that's just where the center of the court was on this. Sure, there were, at the edges, Justice Jackson and others, Justice Sotomayor asking some questions, but it really did feel like this is one after 4 hours of argument, which is itself a pretty rare thing, in which it felt to me like there was more of a consensus. And that'll make this case not, Ari, the blockbuster that, I think some were anticipating this morning, because I think the court's going to follow well-established First Amendment principles from Buckley versus Valeo that says, look, you can't do this. Right.
As you say, it's a very big case, but one more mild or sort of measured way to deal with it is to not take the invitation to do a bunch of new stuff or ponder the internet and just say, hey, we already have case law on this. You can't put your thumb on the scale. And DeSantis doesn't get this power. That would be a loss for him. The tech part was interesting because, as you know, this is an area where Congress and the courts struggle more than perhaps other areas. It's challenging for anyone, let alone folks who grew up in literally a different technological environment. Alito at one point asked something that relates to the press, and we're not, we don't avoid covering it just because he mentions it. It was kind of interesting. Justice Alito said, okay, you're talking about speech, but tech is part of so much. So YouTube, right, you can up or down the anti-vax video, sure. Then he posed the question, quote, what about Gmail? Do they have a First Amendment right to delete, let's say, quote, Tucker Carlson or Rachel Maddow's Gmail accounts if they don't agree with their viewpoints? And that seemed like a fairly elaborate and intelligent hypothetical, because he's pointing out that the rules you make could affect what these tech companies do in all other aspects of our life. What did you think of that question? Did it surprise you as someone who's so experienced? What was he getting at, and what do you make of that? Yeah, like Justice Kagan, Justice Alito, I think, is considered one of the sharpest questioners on the court. Agree with him or disagree with him, but he is. I think it really showed there. And I think he's picking up on something this Supreme Court has felt for at least 2 decades, which is
technology cases are really hard for the court because they don't know where the technology is going to go. They don't want to mess up the economy and the like. I think I've argued 15 or so tech cases at the Supreme Court, and it is a common theme. And so Justice Alito, by asking that question, I think was basically pushing for a narrower decision from the U.S. Supreme Court in these cases and saying, look, this is about YouTube, this is about Meta and Facebook, this is about Twitter, but it's not about Gmail and other things. And so let's leave that, whatever decision we make here, let's have it be a narrow one, not touching those things, which I think is a very smart prudential thing to do in a case of this magnitude.